Here's a crucial point I want you to understand if you care about protecting your gun rights and the rights under the Second Amendment. You see, the anti-gun lobby, as I see it, likes to attack the Second Amendment from all angles. Every possible angle they like to attack. And one of their favorite techniques is trying to drive the gun industry, which supplies us with firearms, right, ammunition and other, accessories, out of business, right? Put them bankrupt, whatever it takes. And how do they do that? Well, one of the ways the anti-gun lobby likes to try to do it, at least, is by suing these companies into oblivion. That's what they'd like to do. And this is what I call, other people have called, a form of lawfare. It's like warfare, except it uses the courts and the legal system in an attempt to drive these gun companies out of business. And when we get back, I'm going to tell you how it works and how it threatens your Second Amendment rights. Hey folks, I'm Mark and welcome to the Four Boxes Diner. Lately, the anti-gun lobby, in my view, has not had a lot of success securing gun restrictions, gun control through the democratic process. In fact, much of the country, especially after the riots of 2020, we've seen much of the country has actually loosened gun regulations and gun control, not increased it. Now, the anti-gunners also, of course, as you know, are in the process of, in my view, striking out at the Supreme Court as well. I think there's a great chance the Supreme Court is going to strike down New York's gun control rules involving the carrying of concealed weapons. We'll find out in June what happens. That is specifically the case of NYSERPA versus Bruen. But even if the anti-gunners lose the Bruen case in the Supreme Court, which I think will happen, do not think for an instant your Second Amendment rights are going to remain safe, because they won't. You see, the anti-gunners are always looking for ways to try to hollow out and destroy your Second Amendment rights, your gun rights. That's always going to be happening. It's been happening for decades. It's not going to stop. Now, this is where the concept of lawfare, warfare with the word law in it, lawfare comes in. Because the anti-gunners like to use lawfare, as I see it, to harass the firearms industry into submission, right? Make it expensive for them to do business and to be in the gun business or the ammunition business. You see, actually winning the lawsuits, as I see it, might not even be the point when they sue the gun industry. All they really want to do is bleed these companies financially dry, right? They want to aim to attack these companies and force them to spend a lot of money and a lot of time and a lot of resources defending these lawsuits, all in the name of making gun companies not focus on what they need to be focusing on, which is manufacturing, making, inventing new guns, selling ammunition, selling accessories, basically catering to the gun community in the United States and the gun customers in the United States. Now, some anti-gunners have been open about this goal. This is not my surmising, it's what they've actually said. Take the member of remember President Bill Clinton? Think about this member of President Bill Clinton's cabinet who publicly warned gun makers that his legal strategy was, quote, death by 1,000 cuts. Do you know who that was? Who was that cabinet member? Let me tell you. It was Andrew Cuomo, the former New York governor back during the Clinton era in the 1990s, who said that. Look, there are a lot of reasons why you want to stay out of court. The obvious one is that lawyers are really expensive. Legal fees can amount to millions of dollars in certain cases and hundreds of thousands of dollars in other cases, right? A lot of money. And in my view, few gun companies can absorb these kinds of crazy litigation costs. They're just too high. And what about the opportunity costs and the emotional toll that come with defending yourself and your company in a lawsuit? You could spend years tied up in court focusing on lawyers and judges, completely distracted from your main business of selling, making, inventing guns and ammunition, whatever it is the gun business is actually in the business of doing. You're distracted by dealing with these nonsense lawsuits. And again, this is especially true because many of the anti-gun cases that I've kind of observed, they seem to be bankrolled by sort of nonprofit special interest groups that have an interest in basically gun control. And many of these anti-gun groups that I've been able to see from my kind of review, this is my opinion, of course, it seems to me they get a lot of funding from some very wealthy people to bring these kinds of cases. So even if the plaintiffs sue these gun companies and they lose the cases, it really doesn't matter because, again, the goal, as I see it, is not necessarily to make money. Often it's just to impose costs on the gun companies and drive up the prices of the guns and the ammunition we're buying if they can't knock the business out altogether. Now I want you to keep something in mind, and that is the anti-gunners have been waging lawfare against the gun industry for decades. I mean, back in the 1990s, that's the 1990s, the Clinton era, liberal cities like Chicago, New York City, and New Orleans all teamed up with various plaintiffs' lawyers to try to destroy the gun industry, attack the gun industry, make them change and do what the plaintiffs and the politicians wanted. And this was all done, by the way, with Andrew Cuomo, then with the Clinton administration, cheering all of these lawsuits on. In fact, they really just tried to hold these gun companies accountable for the murders, assaults, and robberies committed by third-party criminals over whom they have no control, right? I mean, how does this make any sense to hold a gun company liable for the use of a firearm by some third party over they have no control, they don't know anything about these people, there's nothing you could do to stop it. As a matter of basic law, by the way, it doesn't even work. It can't work as a matter of basic tort law. Why don't these lawsuits against gun companies make logical or legal sense? It's because it's absurd to hold anyone liable for criminal activities of a third party over whom you have no control, right? Say you manufacture baseball bats. Let's keep it simple, baseball bats. And say someone buys one of your baseball bats at a sporting goods store, and next thing you know, a year later, they use that baseball bat to bludgeon another person to death. The baseball bat manufacturer cannot legally be held responsible for that assault. I mean, they follow all the rules and regulations, assuming they did that. Why would they be held responsible for a criminal act using a baseball bat? Or think of it this way. People are killed every day, unfortunately, by drunk drivers. It happens way too often. But do you see the manufacturers being sued for that? The auto manufacturers being sued for that? Do you see the alcohol manufacturers being sued for that? The distributors? No, of course not. Because at the end of the day, we all understand that in those crimes, when people do something wrong, they misuse. I repeat, they misuse the products. Right? The manufacturer of the product that gets misused can't control that. And there are many other examples of this in the law going back hundreds of years. Now, state tort laws, which is basically punishment people that have misbehaved or civilly liable, right? A tort is a civil suit based on misbehavior, not a contract case, but it's like negligence, malfeasance, trespass. Any of these things could be state tort laws where you sue to get money if someone has done something wrong, okay? Now keep in mind that state tort law often protects makers of vaccinations, for example, against claims of product defects. Defense contractors, those are the guys that supply weaponry and other materials to the Pentagon. Defense contractors who follow the government's precise specifications, they're protected against product liability negligence actions brought by members of the military. So there's a long history here of not holding manufacturers accountable if someone misuses a product or something goes wrong with their product unless they're ultimately the cause of it, which is not the case when some third-party criminal misuses a product to commit a crime, which is what happens when these gun companies get sued by people that misuse firearms in crimes. If you want to dig into the legal questions here, take a look at the landmark Supreme Court opinion from 1984. The opinion was written by a left-leaning, the left's very own Justice John Paul Stevens, now the late John Paul Stevens. But it supports the dismissal of the anti-gun lawsuits, even though it's from 1984 and doesn't involve the gun industry specifically. Believe it or not, that case involved VCRs, video cassette recorders. Do you remember those things? Right? You may not even remember VCRs. Those were home video players and recorders that existed way before you had things like cable and Netflix and DVDs and things like this. This is how you use cassette recorders to put in rented movies that you might get from Blockbuster into these VCRs and watch the movie that night at home, okay? Now, originally at the start, VCRs, also sometimes referred to as Betamaxes, they scared Hollywood studios greatly. Hollywood studios actually thought that VCRs were a danger to their industry. They thought that these VCRs would be used to infringe on copyrights. And they would do so by allowing people to record programming from television or otherwise. So next thing you know, guess what happened? These Hollywood studios sued all the way up to the United States Supreme Court trying to stop these VCRs and the companies making the VCRs from manufacturing and selling them on the grounds that someone somewhere could use these VCRs to violate federal copyright law, which in addition to being a civil problem, could also be a criminal problem, because if you ever watch a movie, what do you see right up front is a warning from the FBI saying, if you violate the copyright, not only might you be civilly liable for a lot of money, but you might even go to jail. Remember those? That's all in every one of the movies you see now. Hollywood's plan actually almost worked, believe it or not. You see, they brought this case all the way to the Supreme Court trying to knock out VCRs and the VCR manufacturers on the grounds that they could be misused, but in a 5-4 Supreme Court decision, the Supreme Court voted to allow VCRs to be sold to consumers, and the rationale is very important to the gun industry as I see it. Here is what the author of the opinion in that case, John Paul Stevens, wrote. He wrote, quote, this is very important, quote, "The sale of copying equipment, like the sale of other articles of commerce, does not constitute contributory infringement if the product is widely used for legitimate, unobjectionable purposes. Indeed, it need merely be capable of substantial non-infringing uses," close quote. Now, what that means, of course, is very simple. Justice Stevens' logic, as applied to the possibility that the VCR could be misused by someone using it illegally to illegally copyright something or whatnot, was not a legal basis to deny the makers of VCRs from being able to do their business, because there were some legal uses of the VCR. And again, I think Justice Stevens' logic was spot on. You see, manufacturers were not responsible for any potential illegal activity an otherwise harmless VCR could be used for. Now, I like to call this the Stevens test. Remember what Justice Stevens said in that opinion. The sale of a product is fine, perfectly legal, perfectly cool, as long as it is, quote, widely used for legitimate, non-objectionable purposes. Okay, think about what that means. Stevens even said that to be sold in the marketplace, the product only has to be capable of legitimate purposes. Well, we know that the overwhelming majority of firearms sold in the United States today are not being used to commit criminal acts. That's the reality of it. So firearms passes the Stevens test with flying colors. Because again, the Stevens test simply says that as long as a product has a legitimate purpose of any sort, okay, then it is legal. You can't sue to bankrupt it. You can't sue to get rid of it on the grounds that it's doing something wrong. Just because someone somewhere can misuse that product, according to Justice Stevens, a liberal from 1984, a Supreme Court opinion, means that just because someone can misuse it is not a basis to stop that product from being sold or from being sued and knocked out of business. That's not how the marketplace works and the legal system works, as written in 1984 by liberal Justice John Paul Stevens. The problem of frivolous anti-gun lawsuits in the United States became so bad at one point that Congress itself took action in the year 2005. They passed a law protecting gun makers and distributors from being held liable for crimes that individuals commit using those products. It's known as the Protection of Lawful Commerce in Arms Act, or the PLCAA. By the way, one group that supported this law was the United States military. That's right, that's the Pentagon. You see, the Pentagon submitted a letter to Congress in support of this because, guess why? They realized that in order to have a military that has guns, they might want someone that actually can make firearms for the military, and therefore they did not want the United States gun industry destroyed by these lawsuits, because that would hurt national defense, because who is going to sell the guns to the military? I don't think we're going to want to buy our weapons from the Chinese or the Russians. That's my thought, at least. Sadly, the PLCAA has not stopped anti-Second Amendment lawfare. With the help of activist judges, as I see it, in certain blue states, anti-gunners have found ways around this federal law. For example, after the Sandy Hook shooting, the Connecticut Supreme Court permitted the family members of victims to sue Remington Arms, the manufacturer of the gun that the shooter used at Sandy Hook. Something similar happened to a company that made trigger attachments. Although that company actually won the case against it, it had its doors shut anyway. Why? Probably because it could not afford the huge legal fees. I mean, who can, right? The anti-gunners executed, in my view, the playbook of lawfare perfectly, right? You sue, you try to knock companies into bankruptcy or make it very expensive so they get out of the business. That's kind of, I think, the goal of this. In fact, last July, I want to mention, that's July 2021, New York State passed a law to do more of this kind of thing, this exact thing. The law allows New York to target out-of-state gun makers with so-called public nuisance lawsuits if their guns are used in crimes. It's a blatant end run around the federal PLCAA, and the ploy should fail. I think the ploy should fail. But here's the key. Of course, this all depends on how judges apply the law. And if you're a gun company being sued in a place like Massachusetts or a place like New York or a place like California, the odds of you getting a judge that's going to uphold the law in favor of gun companies, I would say, is a dicey proposition at best. Not impossible, but I would not, if I were a betting man, I would not be betting that that would happen. Now, I want to let you know it's not all bad news when it comes to this. I do have some good news for you on the lawfare front against the gun industry. Recently, the Nevada Supreme Court shut down a huge case against gun makers. After the mass shooting in Las Vegas in 2017, the family of one victim sued a bunch of gun companies, including Colt. The anti-gun plaintiffs were trying to again get around the federal PLCAA immunity statute and a similar state law that Nevada had passed back in 1985. And how did they do that? Well, they tried to argue that the laws did not cover the manufacturers of AR-15, such as the AR-15 that the Las Vegas shooter had allegedly used. You see, the AR-15, the plaintiffs argued, was capable of being modified into an automatic weapon and capable of being classified as a machine gun. So the plaintiffs claimed in this case that the gun makers could be held liable because they knowingly sold a potentially illegal weapon. But the Nevada Supreme Court unanimously, that's unanimously, it's hard to get a court to be unanimous on anything, the Nevada Supreme Court unanimously rejected the plaintiffs' claims, and it's not like this court has made up, in my view, a bunch of great, pro-gun jurists. It's that the judges simply recognize that the law cannot be twisted to support the anti-gunners' expansive theory of liability that says if you sell a gun and someone misuses it over whom you have no control, you have to pay that bill. That's absurd. And again, why did the Nevada Supreme Court hold all this up? Well, I think it's relevant if you look at what the Nevada law says that the court relied on. Quote, no person has a cause of action against the manufacturer or distributor of any firearm or ammunition merely because the firearm or ammunition was capable of causing serious injury, damage, or death, was discharged and proximately caused serious injury, damage, or death. Basically, the crucial phrase here is any firearm or ammunition. And for the Nevada Supreme Court, any means any. I'm glad they followed the letter of the law, and that includes guns that can become machine guns. The court said to find in favor of the plaintiffs in that case out in Nevada dealing with the 2017 Las Vegas shootings, they would have to insert the word legal or lawful between any and firearm, but the courts are not supposed to make those kinds of changes as to what the law says. They're just supposed to follow it. Again, the Nevada Supreme Court, I give them credit for this, said that to change the law in a way the plaintiffs want is really the job of the legislature, not the job of the courts. Let's hope that more courts follow the Nevada example and stop reading whatever they want into the federal PLCAA and similar state laws. Because maybe then we see an end to this latest wave of anti-gun lawfare we've been seeing over the last couple years. So let's wrap up. Liberal Justice John Paul Stevens, the late John Paul Stevens, was an enemy of the right to keep and bear arms. He dissented in both Heller in 2008 and the McDonough case in 2010, basically saying that you and I do not have a right or a fundamental right to keep and bear arms under the Second Amendment. I think that's absurd, but that's what he wrote and that's what he apparently thought. Okay? He actually specifically, after he left the court, argued in favor of repealing the Second Amendment itself. That was John Paul Stevens. But nonetheless, in the 1984 VCR case called Betamax, Justice Stevens, no friend of guns, laid out sound logic that should vindicate gun makers and ammunition makers and gun sellers today in our favor. The logic is quite simple. Lawful industries are not to blame for the misuse of their products. But I want to be clear about something. There's no doubt that the late Justice John Paul Stevens' opinion in the Betamax case from 1984 dealing with VCRs, it should be a basis to vindicate gun makers. It should. But I use the word should for a reason. You see, the anti-gun lobby's assault on the firearms industry is relentless. It doesn't matter to them that Congress passed the PLCAA to prevent this kind of lawfare. They're always looking for a way around it, right? If anti-gunners can ignore the clear language of the Second Amendment, right, to keep and bear arms shall not be infringed, pretty clear to me, they certainly can ignore the language of a congressional statute signed into law in 2005 by the Republican President George W. Bush. So yes, I'm happy the Nevada Supreme Court unanimously rejected an attempt to hold gun manufacturers liable for the mass shooting in Las Vegas. It wasn't their fault. It was a terrible tragedy, but was not the fault of the gun companies, okay? It was the fault of the criminal who did the bad act. But the gun companies, I am sure, I have no personal knowledge, but I'm sure the gun companies themselves had to spend 2.5 years in court, and I'm sure thousands, if not millions of dollars. I'm sure it was some large amount of money they had to pay their lawyers, or their insurance companies had to pay their lawyers, and probably their insurance companies turned around and raised their rates if that's happened. That's my guess. I have no knowledge specifically, but I'm guessing that's what probably happened. And again, that was a lot of time they had to spend in court dealing with this situation before they finally won the case in the Nevada Supreme Court. So for the anti-gunners, I think that's kind of their plan. It's the beauty of the lawfare plan they're trying to engage in. So even if they lose the case, which they did in the Nevada Supreme Court, they still have won. And they've won in the following way. The process of the case is the punishment. And why does this matter to you? Because no matter what Congress does, and no matter what the Supreme Court decides, in my view, the anti-gunners are going to keep waging lawfare and looking for ways around these various decisions and keep forcing gun makers and gun sellers to spend money on lawyers and litigation so they're not focused on their core business of making, inventing firearms and whatnot to Americans who want these things, okay? And I would expect more lawfare in the years ahead. I don't think any of this is going away anytime soon, no matter what the Supreme Court is, so it's going to be just a fact of life for the Second Amendment community going forward. Okay? Well, I hope you learned a little bit something here today on the channel. Thanks again for joining me at the Four Boxes Diner, where we serve fresh, hot Second Amendment news and analysis. And if you like what you heard, I'd appreciate it if you could subscribe and spread the word. So we'll see you again next time here at the Four Boxes Diner.
Orders up. Table 2A.